My name is Lynne Golding, and I am the leader of the Fasken Health Law Group and a partner in our Toronto office. I'm joined today by my partners, Erin Porter, Daniel Fabiano, Jennifer McAleer, and Zohar Levy. I'll be introducing them a little bit more later. Before we begin, I would just like to cover a few housekeeping matters. To begin with, I would ask you to please complete the online survey at the end of our seminar. There's a link to the survey underneath the video on your screen. And if we can have your responses, then it really will help us frame our next seminar on seniors housing to be held next fall. And it might help us with other seminars to be held in between then and now. If you have questions during this seminar, please do submit them. You will see a chat box on your screen, and if you input them there, we will do our best to answer them before the seminar is over. If you need any technical support, you will see a tech FAQ or tech support chat, also located next to the chat box on your screen. Please just fill that in, and someone will get on there to help you with your issues. Last but not least, we do want to tell you that we have a wealth of resources about COVID-19 on our website. Please go to our knowledge center at fasken.com for more information. So last year we had our inaugural seniors housing seminar. We started planning for it last spring. I remember, Erin, we were talking about the Gliese Report that would be coming out that summer, which our partner Jennifer was actively involved in. And we thought that there would be a lot of public interest in long-term care homes. And so that would be a great time to kick off this series. Little did we know then how much public interest there would be in seniors homes in the months that followed. So this seminar today is going to speak about issues that have arisen from COVID-19 and its ravages in our seniors' home. We're going to talk about the new commission that the government has created in Ontario to look into issues pertaining to COVID in long-term care homes. We're going to give you some advice about how you should respond to inquiries from the commission. And we're going to talk about another issue that is relevant during COVID and non-COVID times as well, which is granny cameras in long-term care homes. So to get started on this, I would like to introduce you to my partner, Jennifer McAleer. If you were with us last year, you would have heard Jennifer speaking about the Gliese Report. Jennifer is a skilled trial lawyer. She has a lot of experience with public inquiries, including representing our former premier at the Ipperwash Public Inquiry, representing the commission as assistant counsel at the Gouge Inquiry into Pediatric Forensic Pathology, and she represented a long-term care home in the Wettlaufer Inquiry. Jennifer has been recognized for her experience in healthcare by Best Lawyers in Canada. Now today she's going to be presenting on the three-person commission that the Ontario government established to look into the spread of COVID-19 within long-term care homes. She's going to look at the commission's mandate. We're going to talk about what we can expect from the commission and what changes have been implemented as a result of the Wettlaufer report that she described to us last year. So Jennifer, over to you, please.
Thank you very much, Lynn. All right, so let's advance to the first slide. I'm going to start by just talking a little bit about the Gliese Inquiry, and then we're going to talk about a report that came out this summer with an update as to what the government has implemented as far as Justice Gliise's recommendations. So I know that most of the audience will be quite familiar with the Gliese Inquiry, but just to remind people, the Gliese Inquiry, the long-term care homes public inquiry, was established in August of 2017. And it was following Elizabeth Wettlaufer's conviction of 8 counts of first-degree murder, 4 counts of attempted murder, and 2 counts of aggravated assault. And all of her offenses had occurred while she was working as a registered nurse in long-term care homes. And people will also remember that these crimes all went undetected until Wettlaufer walked into CAMH and confessed with respect to what she had done. And but for that, I think the common belief is that we would never have known and that this would not have been detected. And that was a very significant issue at the Gliese Inquiry. Next slide, please. So the mandate of the Gliese Inquiry was to look into the events that led to the offences by Elizabeth Wettlaufer and to inquire into the circumstances and contributing factors. And this is what was important, including the effect of any relevant policies, procedures, practices, accountability, and oversight mechanisms. And that effectively opened the door to the entire long-term care home industry. And because there are so many challenges in the long-term care industry, people came running through that door, and there was significant representation from all stakeholders across the industry at the Gliese Inquiry. And everyone was trying to draw Justice Gliise's attention to all of these significant challenges and problems within the long-term care industry. But through that lens that had been imposed on everybody, which was the fact that this was all about Elizabeth Wettlaufer and her crimes, which truly is an outlier. And there is certainly a lot of challenges in that industry. And it doesn't really relate to healthcare serial killers, but that was the lens that we had to look at all of this through. And it was a real challenge, I think, for Justice Gliese to write a report that acknowledged everything that she had heard and learned, but keep it in the context of healthcare serial killers, which was her mandate. Next slide, please. So let's talk a little bit about the process at the Gliese Inquiry, because it differs significantly from the process that the current Commission of Inquiry is engaged in. So at the Gliese Inquiry, it was a very carefully structured process, and it lasted 2 years. And it started with summons for documents, document collection, months of witness interviews, eventually culminating in public hearings. And there were standing hearings in advance where people had to ask for participant status. So you were almost like a party in a trial, but you're called a participant, and you had to request to be given that privilege to participate. There were then public hearings. Now, following the public hearings, what a lot of people may not have realized is there was a lengthy consultation process where there were meetings that were being held with numerous stakeholders, which were not public, but very much informed the recommendations that Justice Gliese ultimately made. And then, of course, once that consultation process was finished, there was a number of months spent drafting the report. So a very detailed, lengthy, somewhat transparent process, and going to be different than what the Commission is currently dealing with, given the emergency situation that COVID has created. So next slide, please. Now, the Gliese Report was released in July of 2019, so just over a year ago, and there were 91 recommendations. And next slide, please. She tried to categorize all of her recommendations into 4 categories that all dealt with healthcare serial killers, because again, that was her mandate. The first had to do with awareness. How can we make the industry aware that there is such a thing as healthcare serial killers? And again, keep in mind that Elizabeth Wettlaufer is the only one that we know of in Canada. So it is a worldwide phenomenon, but query how common it is in Canada. I think the only one that there's any other definitive proof of would be hospitals for sick kids years ago. And of course, nobody was ever charged with those crimes. The second category was prevention. How do we prevent someone like Elizabeth Wettlaufer from committing similar crimes in the future? Deterrence, how do we deter it? And then detection as well. So next slide. So her first recommendation of the 91 was to call on the province to report back on the progress in 1 year. That was the most important thing for Justice Gliese, because unfortunately a lot of time and effort can go into these public inquiries, and reports are drafted and sometimes shelved, and there's no follow-up with respect to how the government analyzed the recommendations. Did they implement them? What's going on? And Justice Gliese really didn't want to see that happen, so she asked that the government report back in a year, and they did. So next slide, please. So in July of this year, in the midst of COVID, the ministry issued its report back on the Gliese Inquiry. And they make the claim in the report that they have over 80% of recommendations are completed or underway. Now, I will leave it to those in the industry to decide whether or not they think there's merit in that statement. I think completed or underway leaves the door open. At the end of this report that was issued in July, they actually go through each one of the 91 recommendations and they indicate whether in their view it's completed, is it underway, or has it not yet been commenced. But those in the industry will know whether or not they've actually seen any of those changes on the ground. Next slide. So I'm just going to highlight some of the steps that the government says it's taken with respect to each of these 4 categories of recommendations. I don't mean this to be a promotional piece on behalf of the government, so you can decide whether or not you've seen these changes on the ground, but this is what the government is saying with respect to the recommendations that it's implemented. So first, on the awareness, and again, keep in mind this is the risk of intentional harm and how to report it. They've really given this responsibility over to the Office of the Chief Coroner, and the Chief Coroner is developing educational programs and an awareness campaign. Apparently there's a partnership with Queen's. There's a center of excellence focused on elder vulnerability. And then also they indicate that there's a campaign to put up more posters in long-term care homes about abuse and neglect. And I'll just pause there for a minute. I think certainly there were, prior to the Wettlaufer inquiry, there were already those kinds of posters in long-term care homes. And I think there was a real concern by people in the industry that if there was too much more advertising in long-term care homes about the risk of healthcare serial killers, that would actually be quite unnerving to people and would make people feel not safe in their homes and perhaps discourage loved ones from placing their family members in long-term care homes. So I think that continues to be a significant concern. Next slide, please. Now, with respect to prevention, I think the only significant thing I saw in the report was this promise of a new $10 million in education and training investment in the coming year. But they also couched that to say that it's predominantly going to be used in response to issues identified during COVID. So you start to see this overlay of responding to COVID and how that's going to overlap with some of the recommendations from the Gliese Inquiry. Next slide. On the deterrence front, medication management was a significant issue during the inquiry, and the government indicates that it intends to launch a medication safety technology program in 2021. The ministry indicates that it's going to consult with stakeholders in the development of that program. So those of you in the industry who might be interested in getting ahead on that should look for those opportunities to work with the government and consult with respect to this medication safety technology program. And there's also been some ministers' directives regarding the use of glucagon. I can never say this correctly. Glucagon. Hopefully that's correct. Next slide, please. Now, in the deterrence part of Justice Glise's recommendations, as one can imagine, there was a lot of attention paid to staffing concerns, because everyone will know that staffing is probably the most significant issue in long-term care today. So they launched a long-term care staffing study in February of 2020 and released a report along with the report back that we were just discussing in July of 2020, so this year. And that long-term care staffing study was a project between the ministry and an advisory group. And I think, we'll talk a little bit more about what they recommend, but it's actually an interesting report. And if people haven't read it yet, I suggest you do so, because there's a lot of really good content in that report. And again, it's not going to be news to anybody who's in the industry. These problems have been well known for a long period of time, but I think perhaps there's some satisfaction in seeing them in print and some commitment from the government to move forward with respect to addressing this very, very significant issue. They talk about, obviously, the increase in staff in long-term care homes, changing the culture, and I'll talk a little bit more about that. And then obviously an emphasis on attracting and retaining qualified and competent staff. Next slide. So here are some statistics from that study. There are over 100,000 people currently employed in long-term care homes. There are approximately 78,000 residents in long-term care homes. Of those employed, almost 60% are personal support workers, PSWs. And then I found this interesting, really kind of alarming, that 25% of those personal support workers who have 2 or more years of experience leave the sector annually. So that is an incredibly high turnover, and that's a significant problem with long-term care homes. Now, 25% of the employees are RNs, and then of that, only 40% of RNs and registered practical nurses are actually working full-time. All right, let's go to the next slide. So in particular, the staffing report talks about the challenges being this culture of compliance, and we certainly heard a lot about that at the Gliese Inquiry, that you know, everything is structured around the Act and these inspections, and it drives this culture of compliance, which is focused on not getting a negative report from the ministry, as opposed to being centered on patient care and driven by outcomes. And that unfortunately is the culture that's developed in, and how are we going to surmount that? How are we going to change that? And also finding that the current that should be funding model, not finding model, that's a typo, but the current funding model is far too complex and requires much too much documentation. Next slide. So the staffing report identified the following 5 areas of priority: more staff, more funding, no surprise there. The culture, as we discussed, needs to change. The workload and working conditions, and that specifically, I think, speaks to that very high turnover rate that we see in particular with personal support workers, but also the challenge in recruiting registered nurses and registered practical nurses and others into that industry. Looking for more effective leadership and specialized expertise to assist in the homes, and attracting the right people and providing opportunities for learning and growth. So again, that this industry is seen as a place that people want to be, a place that has a future. It's a place that you go to because you have a calling and you really enjoy working with this resident group, and not because you couldn't find work somewhere else, which I think is unfortunately a bit of a stereotype that is still commonly held by some in the PSW and nursing worlds. So next slide, please. And then finally coming back, so I'm going to leave the staffing report now, which was under the deterrence section of the report back, and talk about detection. And again, we're talking about detection of intentional harm, focus on improved death investigations, redesigning the institutional death record. So again, those are both under the mandate of the coroner's office. Some interesting work on statistical modeling of unexpected deaths, trying to spot the patterns, and that again goes back to the issue that that what Elizabeth Wetlaufer did would never have been detected. But then again, you have to look at the numbers for her. I mean, there were, I say only, obviously every death is significant, but there were 8 homicides over a very long period of time. So query whether any kind of statistical modeling would have detected that, or would spot problems in the future. And then last, it's the enhanced inspections, and I think that's what really causes a lot of concern for long-term care homes, because they already feel that they are overly inspected, and again, that feeds into this culture of compliance. And enhanced inspections, well, what does that mean? And I think the hope is that they're more focused on being timely and risk-based, and that they are, effective in what they're inspecting for, and not inspecting things such as whether your meal plan that day matches the menu that you published earlier in the week. That's not a constructive use of an inspector's time, and it's not a constructive use of the long-term care home staff time to ensure that that kind of oversight is in place. We need to be more patient-focused and more outcome-focused. Next slide. So this is the cover letter that came with the report back on the Gliese recommendations. This is a quote from the Minister of Long-Term Care, and she indicates, our government is committed to an ambitious modernization of long-term care and developing a resident-centered system. So that is obviously a nice message to hear. And again, you need to remember this is in the context of COVID. So, you know, although the report back is on the Gliese recommendation, they really are speaking about COVID and what they're going to do about COVID. So that's a pretty significant commitment. We'll have to see whether or not the government follows through. Next slide. So we're now going to talk about the long-term care COVID-19 commission, which is in place. So we'll talk about the mandate, the structure, statement of principles that have been published, the meetings and presentations that are happening, the time frame, and I think most importantly for this group, how to participate if you haven't already done so. Next slide. So the mandate for this commission is to investigate how and why COVID-19 spread in long-term care homes, what was done to prevent the spread, and the impact of key elements of the existing system on the spread. And the commission will make recommendations aimed at preventing future outbreaks in long-term care homes. That's the first part of the mandate. Next slide. The terms of reference are obviously more lengthy than that, and you can find them at that website. Next slide. So the structure, this is not a full public inquiry. It's not pursuant to the Public Inquiries Act. It's actually been called under Section 78 of the Health Protection and Promotion Act, which authorizes investigations respecting disease and mortality. So a little bit of a different genesis than the Gliese Inquiry. Next slide. There are 3 commissioners, and if you are interested in what the commission's doing, I suggest you take a look at their backgrounds. The Honorable Justice Frank Morocco is the lead commissioner. He's a very well-respected judge. He had been a very well-respected practitioner and has been on the bench for a number of years now and is quite highly regarded. The other 2 commissioners don't have legal backgrounds. They have healthcare background, or actually, Dr. Jack Hitz has a healthcare background. He's the former president and CEO of the Ottawa Hospital. According to his bio, did a lot of restructuring in Ottawa. And then Angela Koch is a former senior executive of the Ontario Public Service, a former deputy minister, assistant deputy minister. And again, looking at her background, seems to has had a lot of experience with large-scale restructuring. So just with the choice of these 3 individuals, in particular, Angela Koch and Dr. Jack Hitz, I think the government is signaling that they're looking at a very broad overhaul of the long-term care industry. At least that's what they're signaling with the selection of these people, but we'll have to see what happens. Next slide. They've issued a statement of principles. I'll just review them briefly. First of all, independent, they're arm's length from government. Thoroughness, the commission is going to conduct a very comprehensive investigation to ensure that the questions that are set out in its terms of reference are all explored and answered. Inclusiveness, they want to make sure that they get a full range of input and information from across the industry, and I'll come back to talking about how they're doing this. Timeliness, they have their mandate is to release a report in, I think it's April of 2021, but there's also been talk about an interim report. I've seen Justice Morocco refer to an interim report when he is conducting meetings with different stakeholders. And I think that the challenge for this particular inquiry is they're not just looking at something that's happened in the past and what do we do to make sure this doesn't happen again. They're actually in the midst of it. And the idea is that this particular inquiry will be coming out now or shortly with recommendations to the government as to what they can do to prevent a further spread, given that we're in the 2nd wave and there's even some talk of potentially a 3rd wave. And then flexibility, like any commission of inquiry, there are no set rules. Everyone is different. And this one in particular, I think, really wants to try and be flexible in order to respond to the current situation and provide helpful recommendations to the government that they could try and implement immediately. Next slide. So talked about the Gliese Inquiry and the fact that there was this lengthy process of document collection and witness interviews, and we had standing hearings and then There were public hearings that were well advertised. This is a very different type of commission of inquiry. No public hearings at present, no standing hearings, nobody with participant status. Instead, they've dived right into meetings with stakeholders. And these meetings are not being held publicly. They're all being held through Zoom platforms similar to this. But what they're doing is they are publishing the transcripts from all of these meetings. So they're public in that regard. So there have already been over 24 meetings or interviews. It's usually chaired by one of the commissioners. It's a question and answer format. Those who are participating in the meetings are preparing presentations, but the commissioners will interrupt them and ask them questions. And it's very much an information gathering process. The commissioners are looking to be educated about the realities of the industry, what's happening, why do you think it's happening, what do you think should be happening, what should be doing in the future. Very conversational, very information seeking. And they have a fantastic website. They've been having a hard time having people find their website, because when people Google it, they come across the Gliese Inquiry. So you have to look a little bit before you find it, but once you do, it's a very good website. And they've actually been asking everybody who comes and meets with them to do a link from their website to the Commission's website, so that people have access to that information. But there's a lot of information on this website already. As I said, you can read the transcripts of all of the interviews, so you can see what other stakeholders are saying. You can see whether or not people are advocating for certain recommendations. If you see something there that causes you concern, then perhaps you want to have your say, and we'll talk a little bit more about how you do that. All of the presentations that have been given are also on the website. So in addition to the transcripts, you can actually see any of the PowerPoint presentations or anything that was prepared. A lot of information on the industry, so a great resource for everyone. Next slide, please. I just listed some of the people that have participated to date, but again, there have been over 24 interviews. So if you really want to see everybody who's participated, take a look at the website. Next slide, please. So as I said, the final report is April 30th of next year. This is something Justice Morocco said at one of the meetings. I think he said it at a few of the meetings, that they've not completely decided yet, but they're inclined to issue an interim report focusing on some of the recommendations. So if you have not yet had your say and you want to participate, I suggest you do so sooner rather than later, so that you might be able to inform some of the recommendations that may be coming out in this interim report. All right, next slide, please. So how do you participate? On the website, there is a lot of information about how to participate. They've basically delineated depending on which group you fall into. So residents and families, long-term care staff, long-term care management, and the general public. Next slide, please. For residents, family, staff, and management, so everybody except the general public, you're invited to provide written submissions. It's completely unsolicited. So anybody out there can provide written submissions to the inquiry. So if you have a report that's already authored that you want the inquiry to see, if you have some statistics that you think are important that you want the inquiry to see, if you just want to sit down and write what you think the inquiry should be focused on, you can do so, and you can submit it. You don't have to ask for permission to do that. There will also be a lot of these small group meetings which are already happening, and you can see that on the website. And then there will be other meetings organized by stakeholders for constituents. So if you are a member of a particular group like Advantage or the Advocates Center for the Elderly, or any one of a number of advocacy groups or associations, those groups are having meetings with their stakeholders and then making presentations to the inquiry. Next slide. With respect to the general public, it's really just written submissions. So if you are just a member of the general public, you're not really engaged in the industry, in the sense that you're not employed by it, then you can still have your say by just simply writing to the commission. But if you do so, keep in mind that all these documents are going to be public. And next slide, please. All right, so what's next? The commission website currently doesn't is not advertising what meetings are coming. Obviously, I'm assuming they have a schedule. They know who they're meeting with next, but that's not currently on the website. Again, there's been this reference to an interim report, but we really don't know when that's going to be released, what it might look like, what kind of recommendations might be included. As far as what are they going to recommend, I don't mean to throw up my hands, but I think at this point it's really anybody's guess. They certainly are getting an awful lot of information, and some of these positions will line up. There will be people from all across the industry who are saying the same thing, such as more money, more staff. I think that's a common theme. But then there are going to be some people that are advocating for things that others don't agree with. So my suggestion is that you actually take a look at what people have already said, and if you feel that you don't agree or that you have something that you want to bring to the attention of the commission, you should do so now and as soon as you can, so that it does make it into the interim report, if not into the final report. So Lynne, that is my overview of the current commission and where we are with respect to the reporting back on the Gliese Inquiry. And I'm a little under time, so if anybody has any questions, I'm happy to take them.
Well, Jennifer, maybe I'll just ask a question or two while we wait to see what other questions may come in through the chat line. So again, if you have questions, please submit them in writing through the chat. Now, I don't want to put you too much on the spot here, Jennifer, but I am assuming that there are commissions like this being held all across North America right now. I think that it's fair to say that most of us were expecting COVID to realize itself in Canada the same way it did in Italy, right? We were expecting our hospitals to be kind of the front line of this, and I think we weren't really prepared for the fact that it was going to be our long-term care homes. But from what I've read, this was really true in all provinces and states. Are you aware of other inquiries like this being held in other jurisdictions? And if so, is our format here common for how others are being held?
That's a great question, Lynne, and I actually don't know the answer to it. I would expect that Quebec is doing something along these lines, and I think we had looked at that a few weeks ago, and there was some talk, but I really don't know the answer to that. But the interesting thing about these commissions of inquiry is that they're incredibly flexible, right? So there is no set format for them. It really depends. The commissions are directed by the commissioners, and the commissioners will decide how best to approach it. This particular commission is obviously wanted to hit the ground running and get as much information as they could very quickly in order to try and give some recommendations to the government to deal with, a second wave, which we're now in the midst of, and potentially a third. So that's a good question, Lynne. Unfortunately, I don't know the answer to that. But the other thing too, I should say, is that even though the commission has started this way, it can evolve. And although their report is due in April, they haven't ruled out having public hearings at some point. So we might see some public hearings. Certainly, it's an area that the public is very much interested in, and the commission is going to want to make sure that the public understands that the work that they're doing. So there may be some public, it's difficult because you can't actually have a public meeting, right? Like you can't go, all these public inquiries in the past have had a lot of stakeholder town hall type meetings where they go into the community and they say, this is who we are and this is what we're doing, and please all crowd around and we'll tell you about what we're doing. And of course you can't do that with COVID. So I think they're probably having a little bit of a hard time getting their message out, which is again why we want to make sure that people who are attending here today realize that they are very receptive to getting as much information as they can. So you should feel free to contact them.
Jennifer, do you think that this is a good format for ascertaining truth and facts? You've been involved in a number of commissions that are much more litigious, where there's cross-examinations, where judges were set to find facts. Do you think that this is a good format?
You're quite right, Lynne. It's not an adversarial format at all. people are not appearing with legal counsel for the most part. People are not being cross-examined. People are making statements, and basically there's no one there to, to hold them to account or to say, well, is that really true? Except for the commissioners, right? The commissioners, as their knowledge builds, will become more informed, and they'll be able to ask more probing questions. So that's a limitation of this format, in that there is no cross-examination. But even in public inquiries that we've seen, such as the wet lawfare inquiry or Justice Gouge's inquiry, they're not adversarial processes either. Like, they did have cross-examinations, but it really is about truth-seeking, and there is a way to get at the truth, which doesn't necessarily require really contentious cross-examinations. When we did the Gouge inquiry, we had 2 or 3 months of evidence, and we had one single objection. You try and get through a day at trial with one single objection. It's impossible. So it just speaks to the difference in tone and culture at these public inquiries, that it's much less about protecting a position as it is about facilitating information, making sure the commission understands what's happening. And then the advocacy comes in, trying to make sure that the commission understands how certain recommendations could practically play out, right? Because you don't want the commission to make a recommendation that is going to be onerous on individual stakeholders, or just not realistic or practical. And because that recommendation will not be useful and may not even get implemented. So
I have another question, but I do just want to let our technical people know that based on the way the screen is right now, I cannot actually see the chat box. So if there are questions down there, I can't see them. So this is my next question for you, Jennifer. 2004, I guess, we had a similar commission for SARS, following SARS. Thank you, Andrea. Will the report that was generated after that commission, will that be something that is considered by the commissioners in this case?
I would expect so, Lynne. So this commission has specifically been mandated to take into account the work of the wet lawfare inquiry, but also any other commissions of inquiry or investigations that have taken place that may help inform their knowledge base, and also inform their recommendations. So to the extent that there's work that's been done out there, and of course people in the industry know that this industry has been studied and studied and studied, and there are a lot of reports that have previously been authored and unfortunately shelved, and that have not formed the basis of real change. And it's going to be up to the commissioners to frame it in such a way that it's practical, and that their recommendations can actually get implemented quickly. And they'll be focused on that, right? Nobody wants to spend a year and a half of their life working on something that's going to end up shelved. It's very important to the commissioners that they come up with recommendations that are practical and that can be implemented. And they'll be thinking about that. They'll thinking about, how do I frame this in a way that can result in real change? And they'll be looking at those past reports and thinking about, well, why didn't that lead to change? I want to be informed by it, but how do I make my report different? How do I make my recommendations more practical?
Yeah, it's a lot of work to do if the recommendations are too theoretical. So they will all, I'm sure, being good public servants, be committed to coming up with recommendations that will make a difference. We do have a question, but it is gone. Interesting. We had a couple that were submitted beforehand, so I'll go to those. One is, do you have any sense about whether alternative models of care in long-term care homes, including the use of virtual care, might be a recommendation that comes out of this report?
Yeah, I think it's a good question. I mean, everything's on the table, right? And again, when we go back and look at the choice of commissioners, I think they are looking at a complete overhaul of the industry. I think that's on the table. Practically, whether that will happen is another issue, but that's certainly the starting point, is that everything's on the table. And then, of course, if you layer on the reality of COVID and the fact that we're all working from home and that people are doing a lot more telemedicine and it's become a very virtual world. And how can you not, right? How can you not look at options for virtual care, virtual input, especially I think in they're looking at the long-term care homes, but there's also the reality of home care as well, right? And whether or not there's more room in home care for virtual care, and you know, I don't know if they're going to be looking at areas such as how do we, you know, should there be more people? Well, let me rephrase. There's always been an issue with the population in long-term care home, right? The long-term care homes take a lot of people in who perhaps due to very high acuity issues maybe shouldn't be in long-term care homes, right? We don't have another specialized place to take care of those people, and it's a real source of work and frustration, I think, for the on-the-ground staff in a lot of long-term care homes, that they're being put in situations to deal with people who have very significant mental health issues that they may not be trained to deal with. So that's, I'm digressing a little bit from your question, Lynn, but I think the reality is that everything's on the table as far as who's in long-term care. Should all those people be in long-term care homes, and how should we be structuring our long-term care homes? And is there a way that we can keep more people in their homes? And is there a role for virtual care?
Well, we will look forward to the regulations under the Home Care and Community Services Act to see what the future linkages will be between home care and long-term care. I did find the question that was submitted. It is this: if employers are having difficulty with retaining positions like PSWs, and they have been proven to earn profit in the long-term care home, do you think that these profits should be diverted to frontline staff?
Not sure I completely understand the question. I think, okay, so the idea being that if you have the for-profit long-term care homes, whether or not some of those profits should be used for frontline staff, I think that's the question.
I think that's the question.
Yeah, well, I think that the funding model is quite complicated, and I think that and Erin would know better than I on this, but I think that the for-profit homes don't perhaps have as much latitude with respect to staff and paying for staff as people might think they do. And I think the other thing too is, although they are called for-profit, you know, I think that there are many who could speak to the true profitability of those homes, and whether or not there really is a lot of extra money to go to frontline staff. I don't think that's the real issue. I think it has to do more with the funding model and the way that the government funds frontline staff, and flexibility with respect to that funding, and allowing the long-term care homes, whether they be for-profit or not-for-profit or municipal, more flexibility with respect to how they use those funds in order to staff their homes. That it's to date been very structured and regulated with respect to how to use that money, and you know, the requirements of always having an RN in the home 24 hours and such. Whereas on the ground, it may make more sense to use that money differently, or to use it not just for public, for personal support workers and RNs and practical nurses, but perhaps other people who don't fall within those designations. The home should be allowed to hire those people to come in and to assist with managing the workload, and that currently that flexibility doesn't exist.
Well, thank you very much for your question, Matt. And Jennifer, thanks for taking those questions. It's always nice to be able to delve beyond the slides, so we do appreciate that. All right, we're going to go to our next session now, which is going to be led by Erin Porter and Zohar Levy. So Erin started her law career at Fasken's, and then she took a little 11-year leave of absence and went and became the Vice President Legal Affairs of one of Canada's largest long-term care home and seniors homes. As the Vice President Legal, she really handled every type of legal issue that came before that organization. She came back to us a few years ago and is now a partner in our Labor, Employment, and Human Rights group. And Zohar is a commercial and civil litigator. She enjoys advocacy at all levels, and she's appeared, I think, in every level of court, including the Supreme Court of Canada. So Erin and Zohar are going to reflect on how long-term care homes can improve their COVID response. When we wrote this, we said, in connection with a potential second wave, I guess we now have to say we're in that wave. They're going to talk about how to deal with being targeted with an unprecedented number of civil litigation claims and steps that can be taken by long-term care homes to protect their organization's quality assurance views during the pandemic and beyond. So Erin, I will now turn it over to you.
Thanks very much, Lynn. Good morning, everyone, and thanks for joining us today. Zohar and I are going to talk about how to protect your quality of care reviews, as Lynn said, in the face of really unprecedented litigation. So long-term care, the industry itself is certainly no stranger to litigation. We've seen over the last couple of years a number of class actions have started sprouting up, but certainly with COVID, this has exponentially grown. And it also comes at a time when now, perhaps more than ever, you also want to be looking back and reflecting on what it is that your homes have done during the first wave. What do you need to improve upon for the second wave? Because this is something that none of us have ever seen before, right? So it only stands to reason that there is room for improvement. When you're talking about something that is unprecedented, then of course, you're going to need time to kind of sit back, catch your breath, reflect, and decide what changes to be made. And so we thought it would be timely to discuss how you could do that and to the best extent possible, protect those discussions to ensure that they don't become part of the next litigation or your next class action. And really there are two different ways that you can do that. One of them is a common law privilege, and Zohar, who is in our litigation group, she will talk about that. And then the second is legislative protections. And specifically in Ontario, we'll be talking about QCIPA, so the Quality Care Improvement Protection Act, and how that applies to long-term care homes. The protection isn't extended to retirement homes, unfortunately. So we'll go through these two methods and then talk about why you may choose one method over the other and give you some examples to see what can and cannot be protected under each of these processes. So I will turn it now, we'll go to the next slide and I'll turn it over to Zohar.
Thanks, Erin. And good morning, everyone. So as Erin has said, I'm going to start by talking about common law privilege. And if we can go to the next slide, we'll start with the starting point, which is that in a civil litigation, so that's class actions, lawsuits, etc., lawsuits brought by individual residents or by families of deceased residents, in a civil litigation, you're required to produce all relevant documents in your possession, power, and control. And this is sort of the default starting position. If you've got it and it relates to the claims that are made in the statement of claim, you have to hand it over to the other side. And the exception to that basic rule is if there is a claim of privilege that can be made over the document. And there are, if we can go to the next slide, there are two different sort of broad categories of privilege. There's absolute privilege. So for example, those of you who have had to deal with lawyers or who are lawyers know that your communication with your own lawyer is absolutely privileged. So that means if your lawyer sends you a legal opinion, under most circumstances, unless there's been a waiver of privilege, you don't have to hand it over to the other side in a civil litigation. But most documents don't fall under those absolute privilege categories. And quality reviews don't. There's no absolute privilege that says every quality review you do cannot be produced. But there are still a whole bunch of documents that courts have recognized over the years that should not be, that should be able to be protected by privilege and that should be able to be protected from disclosure. And one classic example of this actually are the documents, counseling records, for example, in the context of sexual assault survivors, where the courts recognize that there's a real importance for those people to be able to go and get those services in a confidential manner, but at the same time, those may be relevant to a litigation. And so those case-by-case privilege determinations are made by courts by applying what's known as the Wigmore test. And just so you all know where I'm going to talk about the Wigmore test and the 4 elements of it. And as I talk about it, I'm going to give specific examples of things that you can and should do in order to make sure that your quality review, if you wish it to be privileged, does fall under the Wigmore blanket. So if we can go on to the next slide, there are 4 criteria to the Wigmore test. And the first criteria, as you can see here, is that the communications must originate in a confidence that they will not be disclosed. Now, it's interesting, there is actually not a whole ton of case law out there where judges and masters have looked at the issue of whether or not a quality assurance review is privileged under the Wigmore test. There are cases, but given the number of medical malpractice type lawsuits, one would think that there would be more. And I think it's because it's a relatively rare circumstance where you've got something that the confluence of events that Erin has already described this morning and that Lynne has referred to as well, where you have the real need and desire to make ongoing improvements to your processes at the same time as you're facing a real risk of liability. So I will refer to the case law, but it's also going to be some common sense tips. So one of the first cases, and the first case that established that quality assurance reviews can fall under the Wigmore test and can be privileged, is a decision called Scott, and it's from 2002. So it's been 18 years. And in that one, the doctor who is the lead reviewer of that particular quality assurance review had to swear an affidavit with the court, which was filed with the court. And in the affidavit, he specifically swore that he told people that the interviews would be conducted in confidence and that the element of confidence was necessary for him to do his work. Now, that being said, and that was fine to satisfy the court in 2002. That being said, as you're going through, if you want to use best practices and make sure that it's crystal clear, it might be useful to have an FAQ form for the participants in your quality assurance review, or to have some sort of written assurance that's given to them saying, you know, it's our goal to protect this. This is intended to be a confidential review, and have a mission statement for the review. And this will be helpful as we go through all of the criteria if you're explicit upfront in terms of what you intend to accomplish with your review and the purpose of the review. It will really help you satisfy the Wigmore test. So the first one is confidence that they will not be disclosed. The second criteria, if we go on to the next slide, and just as a side note, part of the reason why I say writing is better is because as a litigator, I am always very concerned with not just what is true, but also what I can prove if we end up actually having to argue a privilege motion. And even if it is true that everyone expected the quality assurance review to be confidential, unless if the reviewer left or the staff member who was interviewed left, the employee of your organization, or if something happened to them, or if they've left the jurisdiction, they're no longer available. If we have it in writing, it's much easier for me 2 years, 3 years down the road to be able to prove that that is so. So the second element of the Wigmore test is that the element of confidentiality must be essential to the full and satisfactory maintenance of the relation between the parties. And this is a mouthful, but really what it means is, would people still tell the truth and be as frank and give the same disclosure if they thought that it was going to be handed over to opposing counsel in a lawsuit? And in Scott, in that 2002 case, the reviewer gave affidavit evidence that said, where he said, I will be unable to engage staff members in a frank and detailed discussion about what happened in a particular case in a way that will allow me to ascertain whether there are quality of care issues that caused or contributed to the outcome. And that was a very bald blanket statement. And he was unable to elaborate on why it was that he needed that full and frank opportunity for disclosure, why it had to be confidential. But the court still accepted in that case, and it held that it would be understandable for any individual whose decisions were the subject of a critical analysis by his or her peers in the absence of confidentiality to be self-protected, guarded, and concerned about the consequences of any admissions, despite his or her professional obligations and responsibilities. So again, if at the beginning, as you're going into this quality assurance review, you stop and you think about what it is you're trying to accomplish and how it is you're going to accomplish it, and how critical this confidentiality piece of it is to being able to accomplish your goals, and then reduce that to writing, then you've got a really good mission statement. And I use the term mission statement in a very colloquial sense, but a sort of set of guidelines or guidance to go forward with. So then the third prong at the next slide looks at the importance of the quality assurance review itself. So this relation of confidentiality must be one which, in the opinion of the community, ought to be sedulously fostered, which again is a mouthful that just means, do we care? As a public, do we benefit from these communications being able to be had in confidence? And of course, where your goal is to improve the quality of the services you are providing and to help your clients and your patients, then obviously that is one which the courts have no difficulty accepting that that's a relation to be fostered. And again, in Scott and in a later case in 2010 called Redmond, they accepted that it is in the public interest that hospital care and services are effectively assessed and improved to ensure continuously improving quality of healthcare. The fourth prong of the Wigmore test is really where the rubber meets the road. And this is, so many legal tests love to do this. They do a balancing of principles. And the Wigmore test is no different. And the fourth prong really says, look, on the one hand, what does the plaintiff or the class need this report for? And on the other hand, what harm would be caused, or what's the benefit to having this report being withheld and letting the home or hospital assert privilege? And this is done on, this entire analysis is done on a case-by-case basis. But relying on previous decisions, I think you'll probably be able to pretty easily satisfy a court on elements 2 and 3. It's really element 4 where you have to balance whether hospital records or patient records are otherwise available, whether the individuals who are alleged to be involved in the incident that gives rise to the claim, are they available to be examined for discovery? Can we get at these facts in a different way? And if we can get at the facts in a different way, courts will really not see a huge benefit to producing these sorts of reports where confidence is important and confidentiality is important. But there's a critical carve out, and that goes to where we're talking about whether these other facts are available in a different way. And if we can go to the next slide, it's important to note that even if you are successful in protecting your review itself from production, there is always the obligation to disclose the underlying facts. And Erin and I will talk about this a little bit at the end of our presentation, both in the context of a QSIPA review and in the context of Wigmore privilege. But it is, as I said, it's important to know that if you find out something in the course of your review that is a fact, you have to disclose it, even if you are able to maintain privilege over the review itself and the conclusions of your review. And one other note here, just in case we run out of time at the end to talk about this, together with disclosure of underlying facts, typically, other than in very exceptional circumstances, subsequent remedial measures are also things that can be asked about and that could be considered relevant in a civil litigation. So if, for example, as a result of the quality assurance review, 50 new hand washing stations are installed in a home, in a facility, the fact that those 50 new hand washing stations are installed would be discoverable by the other side, regardless of whether or not the review and the analysis that led to the determination of where to place them and the fact that they were necessary, etc., that wouldn't be necessarily producible but the fact of the installation of these hand washing stations would be. So I believe that now takes us over to Erin to bring us home with legislative privilege.
Thanks, Zohar. Okay, so do you QSIPA? And it's one of those things, if we were here in person together, I would ask for a show of hands to see how many of the audience is actually using the Quality Care Information Protection Act. And if so, how many are actually using it correctly? Because oftentimes you can think that you're using it and that the reviews that you're doing are protected, but you haven't maybe taken some of the steps that you needed to in order to ensure that you are protected under this legislation. And as I mentioned in my introduction, currently this is only available to long-term care homes. It's available to health facilities, so hospitals, things like that, laboratories, but it does not define that to include retirement homes, which I think really is an oversight. The fact that the legislation was amended in 2017, I would have thought at that time that they would have included retirement homes, just given the fact that retirement homes now are increasing in the acuity of care that they have for their residents as well. So it is one of those things where perhaps there'll be future amendments, but right now QSIPA will only apply to long-term care homes. So the purpose is to enable confidential discussions where you can discuss errors, systemic issues, and opportunities for improvement, right? So this is an opportunity to candidly discuss what has happened, what went wrong, and how to improve upon things. And I think it's important that you kind of always keep that purpose or that framing in your mind as we go through and we talk about QSIPA. So if we could go to the next slide, please. And what it means is that any information that is gathered as part of a QSIPA review cannot be shared at any sort of proceeding. And it's important that the legislation says that the proceeding shall not permit or require. So even if you came across something or you wanted to share part of your quality review, you can't. And that is what makes it different than when you're talking about privilege, because often when you have common law privilege, solicitor-client privilege, litigation privilege, you can decide to waive that privilege. So if for some reason you wanted to be able to show, for example, that you conducted a thorough investigation as part of an incident, then you could waive the privilege and produce the documents that would establish that. But if you're conducting a review, a quality of care review under QSIPA, you're actually not permitted. You're not allowed to use those documents at all. And the penalties within the legislation are actually quite severe. So if you do use quality of care information that should be protected under one of these reviews, it can result in a fine of $50,000 for individuals and then up to $250,000 for a corporation. So they really have tried to ensure that these reviews are protected. And this legislation also supersedes other legislation. So for example, there may be instances where you're required to conduct an investigation into an incident. So, if you have something where you need to investigate under the Ministry of Health and Long-Term Care, so under the Long-Term Care Act, for example, you might need to investigate something. Under the Occupational Health and Safety Act, you might need to investigate something. And so if you are, those investigators come in and they're asking for these documents to prove that you have done an investigation, you're not actually permitted to hand it over to them. So oftentimes it can mean that you're going to have to conduct 2 concurrent investigations at the same time. It also, the legislation states that even after the Quality of Care Committee is no longer in existence, the information still is protected. So, there is no time limit on how long this information will be protected. It really is an indefinite sort of protection. So they talk about quality of care information and what that means. So Andrea, if we could go to the next slide, please. Not surprisingly, the legislation does define what quality of care information is. And so it's information that's collected or prepared for a quality of care committee. So we'll talk about what exactly is a quality of care committee in a moment, for the sole or primary purpose of assisting the committee in conducting quality of care functions. And again, quality of care functions is another one that is actually defined, another definition from the legislation. And when they're talking about sole or primary purpose, again, I think that's also important. And this is a similar kind of analysis that you would have seen when you're talking about whether or not something is protected by litigation privilege. Right? When you're talking about litigation privilege, it has to be materials that were created for the predominant purpose of litigation. So here we have that similar kind of threshold test. And so it could mean that you are conducting this investigation, and as I mentioned, perhaps you have dueling purposes, right? Perhaps you're also conducting it because you may want to investigate staff for staffing issues or disciplinary issues, or perhaps you're doing it because a staff was injured during this and you need to conduct some sort of investigation under the Occupational Health and Safety Act. And so if you have those dueling purposes, then you may be limiting your ability to rely on this information as being protected under QSIPA. Right? Because now you have diluted the purpose of this information. So really, your quality of care committee should be focused solely on those factors that we discussed earlier. So looking into errors, fixing systemic problems, and doing quality reviews to improve future care. If you look to number 2, so information, quality of care information relates to discussions and deliberations of the quality of care committee. So those are things that the committee would meet and discuss. They would openly talk about issues. They would come up with recommendations. All of those discussions and deliberations do form part of the protected information. Now we'll talk about recommendations and what happens with those in a moment, but at least the discussions and any notes that would be taken as part of those discussions, they would all be protected. Could we go to the next slide, please? And so what is a quality of care committee? And before being able to call yourself a quality of care committee, you might actually be designated in writing to be a quality of care committee. So this is one of those little technical details that oftentimes I think companies have overlooked, where they say, no, we're conducting a quality review under QSIPA, therefore it's protected. But they actually haven't taken the step to turn their minds to designating the specific group of individuals or positions as a quality of care committee. And so you would do that. Typically it's done either by a board of directors or by your senior management. You can have more than one quality of care committee. So depending on the size of your organization, you may have several different quality of care committees, and that's fine. And they can also all report up to one central quality of care committee. So it doesn't need to just be one defined group. In the regulations to QSIPA, it says that there have to be terms of reference, or that you have to have terms of reference which can be disclosed upon request. So if you have to have terms of reference that are disclosed upon request, that means that you actually have to take the steps to have terms of reference to begin with. And again, this would set out what is the purpose of your committee, and you would probably tie it back to what is set out as the purpose of the act at the very beginning. So these are the two kind of little technical details that you have to take before establishing your quality of care committee. Next slide, please. The other definition that's used is a quality of care function. And so what is a quality of care function? And so these are the activities carried out for the purposes of studying, assessing, or evaluating the provision of healthcare with a view to improving or maintaining the quality of care. So again, getting back to that predominant purpose of always looking to improve the care that's being provided. And it says that it can include a critical incident, but it's important here that it doesn't have to be a critical incident. So you can be looking at either things that are big and large, or even small things that you think, may have a broader and larger impact. So it was a small incident, but you think it could signify a larger trend. Next slide, please. Just as important as what quality of care information is what it is not. And so this means that you can't just sweep everything under the protection and try and call it quality of care information. So information in the resident record, for example, is not going to be protected. That has to be disclosed. And then information in any record that you're required by law to keep, again, that will need to be disclosed. And number 3, this is very similar to what Zohar was speaking about when she was talking about privilege and what could be protected under Wigmore. So the underlying facts of what occurred, you're not going to be able to protect that. You can't hide the facts. If there was any sort of cause or harm to a resident, you can't try and shield that under a QSIPA review. And similarly, any consequences that you become aware of, either to the resident or more generally to the resident population, those won't be protected. And then any actions or recommendations that are actually implemented. So if you make changes to your process, Zohar had used the example of having more hand washing stations. So similarly, if that's a recommendation out of a QSIPA review, or a change in your hygiene process, or maybe now you have an IPAC committee, or you've improved somehow your infection control measures, those steps themselves won't be protected. How you get to those steps, or why those recommendations come into place, it's likely that would be protected, but the actual outcome won't be. And similarly, if you're going through a review, oftentimes you may come up with new information, and you may find information that wasn't charted, that should have been charted. So as part of the professional practice, the nurse would likely go in and make a late entry. They would mark that in the chart as a late entry. And so, of course, now it's become part of the record and the resident's chart, and that's all disclosed to the resident. Next slide, please. So if we're looking at QSIPA and we want to talk about some practical tips, I've given a top 10 list. We won't do, I guess, David Letterman style, where we start with number 10 and work our way back, but we will talk about 10 tips. So the first one, have your senior management team or board of directors appoint in writing your quality of care committee for the purposes of QSIPA. And so it can be a very easy resolution that basically says almost exactly what's in the slide. These are the people that are being appointed for the purposes of QSIPA. And then have the quality of care committee establish terms of reference, keeping in mind that these terms of reference will be required to be disclosed upon request. Again, just depending on the size of your organization, you may have a quality of care section on a website or something like that. So you may want to just proactively have those terms of references posted. You're going to want to develop a written policy outlining your quality of care review process. And so particularly spend some time thinking about what would trigger a quality of care review. What happens when a critical incident in most circumstances occurs? Who does it get reported to? Who are the first people who start to investigate? Do you want the investigation to start before your quality of care committee is in place, or do you need the quality of care committee to be in place right from the beginning? So spend some time thinking about that, and you'll likely have a little roadmap of or a decision tree about when to invoke your quality of care committee and when to just go through a typical incident report. Number 4, so the review must be conducted by or for the quality of care committee for the purposes of improving quality. And so it doesn't have to always be the quality of care committee. So you appoint 5 people to that committee. It doesn't have to be those 5 people that go out and investigate every single review. Typically what would happen is, again, in writing, the quality of care committee would designate certain individuals to investigate an incident. And, you know, in my experience, what we would do is have that form where they're being appointed to conduct that review, remind them of the fact that the information is confidential, to mark all certain documents as being confidential, again, just as a reinforcement of the process that you've established in your written policy. You also want to establish regular meetings to ensure that the reviews that are conducted are actually followed up upon. So you'll have recommendations likely from your review. Who's following up on those? Who's making sure that they happen? Who's keeping track of all of those different issues? Because you don't want to spend all of this time and effort making these recommendations and then not actually do anything with them or lose track of them. You're going to mark all documentation created, including your emails, as being protected under QSIPA. So again, you can just have a standard tagline that would be on all documentation. You're going to save your documentation in a secure place and consider what to do with your written notes. Do you shred them? Do you scan them into the folder and then shred them? And remind all of those being interviewed that they're being interviewed for the purposes of quality care review. So again, this is similar to what Zohar was talking about. Your findings, you're not allowed to disclose findings to anyone. We talked about that earlier, except for management. So you can tell management for the purposes of improving quality or if there are concerns about ongoing safety. And then finally, you're going to keep your recommendations separate from the rest of the report. Because the recommendations themselves and what you do are public information and can be disclosed, keep them separate from the report so that there's no argument about what should be disclosed and what shouldn't. Okay, and next slide, please. So I'm conscious of time. I think we did have 2 points or 2 examples. I think we'll go through them quickly, and because we did leave a buffer at the end for Q&A, so that hopefully Daniel, if he needs more time, can eat into that. So examples for discussion. So the first one, and Andrea, yeah. So what is protected? As part of the review process, your patient charts were reviewed and they're examined. Do they have to be disclosed? So Zohar, under your common law, do they have to be disclosed?
Absolutely, they do. As I said, the obligation is to produce all relevant documents in your possession, power, and control. And patient charts are a business record that you would create in the normal course of doing your job, providing services to these patients. So they have to be disclosed. The charts themselves have to be disclosed if they're relevant.
And that would be the same for a QSIPA review as well. Those charts are going to be disclosed. And you know, under a QSIPA process, the fact that you have done a QSIPA review is not protected information. So that's going to be information that is shared typically with the resident of the resident's family. Great. Next slide.
So on this one, this is a little bit more nuanced. So in an interview, Nurse Jones tells an interviewer that she believes the policies in place were insufficient and should have been better. So there are 2 potential things that could be disclosed here. First is the interview notes themselves. And the interview notes themselves, assuming that you are successful in showing that the review is under Wigmore privilege and should be treated as privileged, the interviewer's notes do not have to be disclosed. And then the next question, under common law. And then the next question on this slide is whether or not Nurse Jones's opinion about the policies has to be disclosed. And this is a little bit more controversial. And if we have time at the end, we're happy to engage in a little bit of a discussion about the gray line between facts, which do have to be disclosed, and information which does not have to be disclosed under Wigmore privilege. As you may recall, the decision in Scott and Hospital Council was clear that they understood they have to produce the underlying facts. But in this case, Nurse Jones's opinion, I would say, is not an underlying fact. The policies in place would have to be disclosed if they're written policies, or if they are not written policies, then they would have to be described if they were asked about on discovery, but you don't have to volunteer Nurse Jones's opinion. And in general, it is not appropriate in civil litigation to ask one health professional for their views on the conduct of another health professional if they're actually witnesses or defendants. That's not their role. But that's an entirely different can of worms that I don't plan to get into with given that we're already 5 minutes over.
Well, and again, I think it's very similar in a QSIPA review, is that you would have to disclose the underlying facts. You would not have to disclose the interview notes, and you would not have to disclose an opinion, again, because an opinion is just that. But things, for example, such as the policies, all of that is going to be disclosed, presumably anyway. So that information will already be in the public domain. And we did have a question come in about what to do if you, as part of your QSIPA review, you find out that there was somebody who was either incompetent or potentially there were even illegal acts that came up. And I think, again, we go back to, it's very similar to the Nurse Jones situation, right? That under QSIPA, facts are not protected. So if the fact is that someone engaged either in, a medication error, somebody was not up to standard in performing a medical task, all of those things, those facts have to be disclosed. And also the cause of any injury or harm has to be disclosed. So you don't get to protect yourself under QSIPA. And in most cases, I think people wouldn't be looking to protect themselves. They would want to do the right thing and not run afoul of QSIPA. So I think you would be able to justify providing that information, for example, if you needed to authorities, the College of Nurses, the police in some circumstances, if you had to. I think also that in many circumstances like that, my recommendation would be to do a second investigation. And I know it's cumbersome and time consuming, but because you still can't produce all of the notes and witness statements that you would get as part of a QSIPA review, I think it's going to be important to go back and do a second investigation. And then that investigation and those notes can be used for any staff disciplinary purposes. Those notes can be provided to the police or to the College of Nurses, and that information. So you're relying on information or facts that were derived from QSIPA, but then you're going ahead and doing a second investigation to make sure that you have all of that foundational support that you need. Zohar had mentioned that as a litigator, she, it's great to hear what you say, but she wants to be able to prove it. And so again, we would want to be able to prove that in any sort of labor arbitration or something of that nature.
So, just on the reporting note, I was also going to add that as I'm sure many of you, if not all of you, are aware, there are also various statutes that create mandatory reporting obligations. And so while QSIPA, just going back to look at Erin's slides on my other screen, while QSIPA precludes disclosure during a witness or a court or other body in holding a proceeding, that does not equate to the ability to get out of mandatory reporting obligations, nor should you try to do so.
Well, thank you so much, Erin and Zohar. I'm going to tell you, I can't count how many times I call up Zohar and say, is this privileged? And Zohar runs through the tests. And Erin, I have spoken about QSIPA over the years. I have written about it, and yet your presentation reminded me of a whole bunch of things that it's just a lot of detail to remember. So a great refresher. We're going to keep this session going for another 5 minutes or so. So if you have other questions, please feel free to put them in the chat right now. we'll rearrange the time a little bit so that Daniel starts at 10:30 and he'll finish us off. I have a question for you two ladies, because I have experienced the frustration that patients or family members have because of the whole privileging issue, whether it's under QSIP, it's mostly under QSIP, but to be honest, rather than privileging. We have this accepted wisdom now that if hospital or healthcare provider apologizes, that this kind of, it eases a lot of the pain and suffering that the patients or family have. And that kind of goes against some of this confidentiality that is created through the privileging process. How do you reconcile those two different public policy perspectives?
And I'm not sure that, we'll see if this answers your question. If not, then hold me to it, Lynn, and back. But you know, there is legislation in Ontario, the Apologies Act, which states that one can apologize for something and that apology cannot be used against them in subsequent litigation. And I think that actually has sound public policy reasons for it, because I think that they're, you know, saying I'm sorry, and, you know, a very Canadian thing to do at the best of times, but saying I'm sorry for something, because, you know, often that does go a long way, and it does make people feel better. And I think a lot of times either individual care providers or organizations are sorry that patients or residents or family members are feeling how they're feeling, right? Whether they're willing to accept blame for that or not. You know, so I think that being able to provide an apology can be a very meaningful process for all involved. But I think that being able to do that without having to say, oh, and here are all of the things I think we did wrong, you know, because that's protected. I think that we have to recognize that people won't be as honest and forthcoming in talking about ways that either an organization can improve, or they themselves can improve, or that their colleagues can improve, right? People don't want to rat out their colleague. So if you don't have those protections in place, then I think that you lose some of that ability to be candid. And by losing that ability, then I don't think we get the best outcomes. And I think that people who are in healthcare, people who are in this industry, in long-term care, in retirement, they're in it for a reason, right? Everybody is there for the most part because they are passionate about their residents and the work that they do, and they want to be the best at the work that they do. So I think that we should be trying to allow them an avenue to do that.
And I think also, I mean, in the context of a litigation, at least, typically by the time you're dealing with a litigation, you've got the ability to investigate the facts, and the families have retained their own experts to give the opinions on all the ways that things have gone wrong. And so if you're just talking about on an institution to individual level or individual to individual level, having that genuine human connection and being able to apologize, often for families and for patients at that stage, at least in my experience, it's less about laying blame and finding fault, and much more about how do we make sure this doesn't happen to anyone else. And that is not typically something that would be protected by privilege in any event, as we've talked about, you know, the installation of the additional hand washing stations, the recommendations from the QSIPA review. That would be something that you could talk about and give the family comfort that the lessons have been learned and we're going to do better next time. The timing on that, of course, will be difficult because you don't get to your recommendations at the same time as you typically have your initial meeting, but that's another way to deal with it on a human level without running afoul of either running the risk of waiving more privilege or running the risk of running afoul of QSIPA.
I think those are good responses. We have just a couple minutes left. Is there a little bit more you could tell us about the difference between facts and beliefs in these processes?
So as I had said earlier, that's really a tough one because so often the line is, you know, there are some things that are really clear, and we, in fairness, cheated a little bit in our examples and went for ones that were low-hanging fruit. So, you know, someone's belief about the policy is certainly a belief, but, you know, if someone believes that they saw another staff member going into the patient's room at night, is that a belief or is that a fact? And as I said, it's very gray, and in a typical litigator answer, I will say it's determined on a case-by-case basis. So that is the sort of statement, though, that should lead one to probe a little bit further and say, well, why do you believe you saw that person going into the patient's room at night? And if they say, well, you know, I heard the door slam and they were down the hall earlier. Okay, then those are the facts, right? The facts are they heard the door slam and this other person was down the hall earlier. But the belief in that conclusion is a little bit, I would argue, potentially too far in terms of what you have to disclose. But it's really nuanced and has to be done on a case by case. Erin, I don't know, do you have any better insight than that?
No, I think you're right that it does depend on the circumstances and the situation. I think too that when you look at it, and it's important, as you said, to differentiate between the actual facts and the conclusion of those facts. So the fact could be that the opinion is there weren't enough hand washing stations. Now, that's an opinion. The fact is there were 6 hand washing stations. You know, that's the fact. There are 6 hand washing stations and 300 staff members. Now, one could jump to their own conclusion about whether 6 hand washing stations for 300 staff members is sufficient or not sufficient. But the actual facts are just the numbers. You know, what are the concrete things that you could point to?
Well, that's very helpful and really shows the importance of speaking to litigators or good lawyers like yourself to help people drill down into what they truly do believe is a fact or an opinion. So thank you two both very much. Oh, wait a minute. There's one more question in Q&A. Sorry, give me a sec. QSIPA applies to hospitals, independent health facilities, long-term care homes, licensed medical laboratories, and specimen collection centers. Does it apply to Lynne's or Ontario healthcare teams? I can probably answer that if you can't. Are you able to?
Well, I was going to say no. According to the regulations, it doesn't apply to those entities. Although on a healthcare team, you could designate your quality of care committee to be the long-term care home or the hospital that's associated with the Ontario healthcare team could identify a quality of care committee and do a review. The question would become, who can they share the results of that review with? Because QSIPA says that you can share the results with management. So query whether or not the board or the members of the Ontario health team would be captured under that. So, you know, it's likely that QSIPA, at least as it's currently enacted, will not apply to those organizations. Lynne, I don't know if you had.
Yeah, I was just going to remind everyone that an Ontario healthcare team, of course, isn't a legal entity. It is, at this point, at least, none of them have been incorporated. So really, they are comprised of a number of member organizations, and many of those organizations would fall into the entities that were subject to QSIPA. Well, Zohar and Erin, thank you so much for your talk. That was really terrific. And we're now going to hear from our last speaker, who is our partner, Daniel Fabiano. So it has been 7 months since I have done any work in my office on the 21st floor of the Bay Adelaide Centre, but I still think of Daniel as being the person who is working beside me because his office is beside me on that floor. So Dan is a business lawyer. He's got a great practice in the area of privacy and procurement and technology. He has sat on a number of boards that do procurement for hospitals and healthcare organizations, or who set standards for them in the procurement area. And he also had a stint as being the interim general counsel to eHealth. So he's got a really great expertise in those areas, and he's going to speak to us today about Granny cams. Now, we all know that those iPads that seniors' homes passed out to their residents so that they could connect with their family members when they were not able to see them in person were a real blessing. But of course, that's only one aspect of the use of cameras in long-term care's homes and seniors' homes. I keep saying we all should have invested in cameras. There are so many cameras everywhere. But Daniel's going to talk to us about the legal benefits and pitfalls of having cameras in seniors' homes. So Daniel, over to you, please.
Thank you very much, Lynn. Good morning, everyone. Maybe before getting into the slides, I'll set the stage with a couple of scenarios. These are scenarios that I'm sure many of you have faced. The first being where a resident or a family member comes forward and wants to put a camera in the resident's room, trained on the resident. And maybe they're doing it because they suspect inappropriate mistreatment of the resident. Maybe they just want to keep an eye on their loved one. It could be either. Another scenario, though, is where your staff discover a camera in a resident's room and learn that it was placed there by a family member some time ago. Now, these are different scenarios, but they lead to similar questions and similar issues, which this presentation will explore. So let's dive in. Next slide, please. Granny cams are not a new issue. The technology has been available for some time. Cameras have been miniaturized over the decades, and it's pretty easy to deploy these technologies, and it has been for some time. They may be installed, as I say, by family members or by the resident to help monitor the loved one and the care they receive. They could also be installed to keep an eye on personal belongings, and they may even be used to keep in touch. So a camera may be placed in a permanent position, but it may have two-way audio to enable the family to communicate with the resident. Now, COVID-19, of course, has brought a new emphasis to this as family members are not able to visit. And they may want to keep in touch during visitation restrictions. But as I mentioned in the second scenario at the outset, as many of you can attest, these cameras are often installed covertly without the home's approval or the home's awareness. Next slide. So there are two questions that guide this presentation. First, are there any legal restrictions or issues if these cameras are used to monitor a resident? And then the second is, could the home be liable for cameras that are installed by the residents or their family members? Now, there's some uncertainty in the wider community on both these questions. When I've been working with clients on these questions, the client's initial positions vary widely, but this presentation is going to hopefully unpack some of the issues, and then we'll discuss some of the mitigation options. So hint, there is liability for the home. So there's a hint for the second question. Next slide, please. Just so we're all operating from the same baseline, I think it's important to remember whose privacy is affected by these cameras. Obviously, it is the resident who is the subject of the surveillance. That resident could, is ostensibly being viewed and monitored 24 hours a day, and everything they do in their room is captured. But it goes beyond that resident. It could include other residents. Perhaps there's a roommate, and that roommate is also captured by the camera. Perhaps other residences are coming by to visit, or other visitors, other family members and friends are coming by. And of course, the home's employees would be caught on camera when they entered the room. So it's important to think about this from the perspective of the resident, visitors, other residents, and employees of the home. Next slide, please. So let's briefly review where legal restrictions or liability may come from. Now, this presentation is going to focus on long-term care because there are some additional considerations, but I think this is highly analogous to what would be found in a retirement home. Retirement homes face largely the same issues. So let's kick down through the first set of bullets. Obviously, for long-term care homes, it's the Long-Term Care Homes Act, which governs the operation of those homes, and as we'll unpack a little bit, provides residents with certain rights. We also have Ontario's health privacy law, the Personal Health Information Protection Act 2004. But besides health privacy, there is other privacy legislation that will apply to the home, and it varies. And often when I'm engaged in a privacy analysis, I have to understand the exact nature of the entity and where it operates in order to trace back which privacy law applies. So outside of the healthcare context, If you're a private sector home, then you're concerned with the federal privacy legislation, PIPEDA, the Personal Information and Electronic Documents Act. That's for private sector homes. If you're a public sector home, it depends on who the license holder is as to which privacy law applies. If it's, say, a hospital license holder, then the home would be also subject to FIPA, the Freedom of Information and Protection of Privacy Act. That's Ontario's provincial level public sector privacy law. And if it's a municipal license holder, then it would be the Municipal Freedom of Information and Protection of Privacy Act. Now, those last two public sector laws are nearly identical, and so the issues are very similar. Aside from privacy laws, some of you may be surprised to learn that the criminal code is also at play. It is possible a criminal code violation for the installation of these cameras. We'll unpack that in a bit. And then beyond that, we've got common law issues and potentially collective agreements as well. Next slide. Great. This is the slide I want. So under the Long-Term Care Homes Act, you know that there's a provision for a resident's Bill of Rights. And there are three rights that I would say are specific to resident privacy. And they're listed here. That every resident has the right to be afforded privacy and treatment and care. That every resident has the right to communicate in confidence and receive visitors in private. And that residents have the right to meet privately with their spouse or another person in a room that assures privacy. If a home is to allow the installation of cameras, then the home could be potentially failing in respect of these 3 points unless it has the consent of the resident. And this Bill of Rights creates a positive obligation on the home, and so is something that their directors and officers and management needs to ensure is reflected in the home's operations. And so if cameras are being deployed, this is something, the Residents' Bill of Rights is something that the home will need to consider in deciding whether the particular deployment is appropriate. Next slide, please. Then we have Ontario's Health Privacy Law, PHIPA. This applies to healthcare providers, including long-term care homes, and how they handle personal health information collected as part of healthcare. Now, although this act applies to the home, it doesn't apply to the resident or their family members. The home must ensure that its operations comply with this act, which includes, in the similar ways as the Long-Term Care Homes Act would provide, which includes safeguarding the privacy of residents. Next slide, please. I talked about other privacy legislation. I'm not going to unpack exactly how each of these pieces of legislation works because we don't have enough time to cover that in detail. But the point is that there is other privacy law besides the health privacy law that applies to homes. And it covers personal information that is generally not caught by the health privacy law. And I mentioned the 3 statutes. Now, these statutes clearly, These statutes clearly apply to visitor personal information, folks who happen to be in the room visiting the resident. It also could arguably apply to employee information. And I say arguably because it's a bit nebulous and frankly, somewhat untested. I say this because PIPEDA, if you're a private sector entity, PIPEDA generally does not apply to a provincially regulated employer in their handling of employee personal information for employee purposes. So private sector homes generally do not have, are not concerned with PIPEDA when it comes to dealing with their own employees. And similarly, FIPA and MFIPA generally don't apply to employee personal information. There are some exceptions, but there are large carve-outs for how those 2 statutes apply to employee personal information. So at first blush, you may say, privacy of employees isn't covered by these laws. But I'm not sure that that's the right answer. And I certainly would want to tread cautiously on the theory that external surveillance by some external party could I think be seen as outside of the bounds of an employer-employee relationship. And so unless that surveillance occurs in accordance with employer sanctioned parameters where the employer has set some ground rules on how that external surveillance can occur, if that isn't in place, then I think employees could make a claim and allege that their employer has breached these privacy laws. Next slide, please. The criminal code is also at play, and there's a potential for criminal prosecution. Except in certain law enforcement situations, it is a criminal offense to intercept a private communication without the consent of one of the parties? I mean, this is a question that from time to time comes up in my privacy practice. Can I record a conversation that I'm going to have with so-and-so? Well, generally in Canada, the answer is yes, as long as one of the two parties to the conversation knows that the recording is occurring. Now let's transpose that to a granny cam scenario. So we've got a camera or recording device that picks up a conversation in a resident's room. Well, it could be picking up a conversation between a resident who doesn't have the capacity to consent and another person. Well, that would seem to be, on its face, a violation of this criminal code provision. Similarly, you could also be in a situation where the camera is capturing a conversation between other people in the room where the resident is away or the resident is asleep, and those two people are not aware that the conversation is being recorded. Those scenarios could easily trip the criminal code provision and result in criminal prosecution. And this primarily, and you may be thinking this primarily creates risk for the individuals that are actually placing the camera or the recording device that captures audio, right? It's the family member or the resident that sets up the camera that it covertly, without going through the home, that is the one who's clearly the offender in this context. But that being said, if a home is aware that a camera has been placed and does nothing about it, takes no steps to address that fact, just simply ignores it, then I would say that home too could face liability for allowing the interception of private communications to occur on its premises with its knowledge. Let's go to the next slide. Cameras could also result in civil claims, in particular tort claims based on the tort of intrusion upon seclusion. Some of you may have heard of this tort. It arose, I believe, in 2012. It's been around for a little while. It is continually evolving. It's sort of something that courts are gradually building upon and unpacking. But at a high level, the tort is engaged if there is intentional conduct that results in an invasion of the private affairs of an individual, and there is no lawful justification for that invasion, and a reasonable person looking at the situation would see that invasion as highly offensive. If those elements are engaged, then there would be a valid basis for a claim under this tort, and a court could award damages. So applying this to a granny cam scenario, if someone has a reasonable expectation of privacy, so a resident's room, for example, and they're captured on video, they could potentially claim under this in this tort. And we know, of course, in long-term care, there are cameras in the public spaces. There are security cameras in various places, and that's a different issue, right? Someone coming in the front doors of a long-term care home does not have a reasonable expectation of privacy. So this tort isn't something that is of concern to cameras generally. It's the cameras in the resident's room. And I think we know that, I'm sure we know that under the Long-Term Care Homes Act, it enshrines the home principle right off the bat in Section 1, the notion that the long-term care home is primarily the home of the residents. And of course, the resident's room is truly the nexus of that principle. We also know that in similar circumstances around cameras being used have been litigated and damage awards have been made on the basis of this tort. One notable case is where someone set up cameras that captured what was going on in their neighbor's property, which is somewhat analogous to the situation we face here. And the court awarded damages in that case and found that the home is a place of seclusion, and so very likely any intrusion upon that place and the privacy of that place would be enough to trigger that tort. And just to be clear, although the resident probably has the best claim for intrusion upon seclusion if they weren't aware of the camera that was in their room, that claim can still be made by others whose privacy was invaded, including other residents, friends and family who are visiting, etc. It's not just a matter of the resident. And maybe just for context, a claim under intrusion upon seclusion can result in moral damages. So even where no harm has been proved, there's no evidence of, say, financial harm or reputational damage and so forth, courts can award moral damages of up to $20,000 in addition to actual damages. Clearly, no home wants to be embroiled in any litigation in terms of using up the home's valuable resources, and would certainly not want to be subject to a damages claim in this vein. Next slide, please. I mentioned earlier that employee privacy is a concern, and I referenced some of the privacy statutes, but the general principle is that employees can have an expectation of privacy in the workplace, and employers who engage in video surveillance will have to justify that surveillance based on a demonstrable need and a minimum invasion of privacy. Now hit the next bullet. Arguably, though, if that's the employer requirement, but arguably the same principles apply if an employer permits or is aware of the fact that some external party is surveilling their employees, whether a resident or a family member. Next slide, please. And there's also labor law implications, and we'll activate the bullets. For example, collective bargaining may result in agreements with unions, including terms that allow the union to object to policies that the employer implements. And conceivably, this could include a deficient video surveillance policy, so a policy that perhaps captures the home's cameras but doesn't address the issue of granny cams, or where there simply is no policy to cover this, and so the home does not have a standard approach to it. Next slide, please. I gave a bit of a sense of liability, and clearly, let's just sort of recap across those various heads of liability. Clearly, the resident or the family member, whoever it is that put the camera there, will be directly liable for their action, whether in tort or in criminal law, and so forth. But as I've mentioned in a few instances, the home could also be liable if it was aware of the camera, but did not take appropriate steps to mitigate the privacy impact. Note, I didn't say that the home has to prohibit the camera, and I don't believe that the home has the legal ability to prohibit the camera. This is the resident's room is their home, but rather the home has failed to impose appropriate parameters to mitigate the privacy impacts of that camera. We'll go to the next slide, please. So let's talk about how homes can set those parameters and how homes can mitigate their liability for granny cams. A key mitigation measure is to implement a video surveillance policy. Now, homes should already have video surveillance policies. If they have security cameras installed to monitor public spaces, those cameras need to be governed by a video surveillance policy. Privacy Commissioner guidance on this point is clear. A policy needs to be in place for those cameras. But of course, we're not talking about cameras that the home can control in the case of granny cams. But that still does not mean that the homes can't impose these parameters. And the policy on granny cams should really balance these competing interests, which I think are obvious. The interest of families and the residents to use these cameras, given that the resident's room is their own private space, and balancing that with the privacy rights of employees and residents and other visitors. It's also important to be proactive and to get in front of families that might install cameras covertly. So let's talk a little bit about what the policy should cover, what key elements the policy should cover. Next slide. So these are the key elements. I'll unpack them each briefly. Consent, assessing the field of view, dealing with audio recording, registering the existence of the camera, posting notice signs, and then proactive communication of the policy. Next slide. A foundational element of a granny cam policy is consent. And so it's important that the home consider who must consent to the installation of this camera. Clearly, the resident needs to consent. And any roommate that will be caught on camera also needs to consent. And if either of those two individuals lack capacity, then it's the substitute decision maker that would have to provide their consent. Without that consent, it's a no-go. The camera cannot be installed in the room. For the home's purposes, it's also important to get that consent in writing so that it has evidence to prove that it obtained that consent. And it's also important to note that these consents are revocable, meaning that at a subsequent time, a roommate could say, I'm withdrawing my consent, I'm revoking my consent, which means that the policy and the deployment of the camera needs to be nimble enough to account for that. And if, for example, the resident who has capacity withdraws their consent, the camera would need to be removed. Consent is the foundational principle here. Next slide, please. And this is relevant, this next piece is relevant, I think, to the roommate issue. The field of view of the camera needs to be carefully calibrated. You can envision a situation where the camera is pointed, say, directly at the resident's bed or the resident's sort of key living space, but the camera could also have a field of view that encompasses a roommate who's not provided their consent, or could even be aimed so that it captures what's happening in the hallway outside. Those latter instances should not occur. The camera should not be capturing other residences who have not consented, and the camera should not be trained on public spaces. And it may be the case, depending on the nature of the camera and how it's set up, that the home will need to validate or audit or assess that the field of view is in fact appropriate and that those other spaces are not caught on camera. Next slide, please. Let's talk a bit about audio recording. If the camera is able to capture audio, this introduces considerable risk for everyone, for the person who's installed the camera and for the home that's permitting it to be installed. Next bullet. While video cameras can have a fixed field of view, and as long as the camera isn't moved around, you know what the camera is capturing, recording audio raises the risk that the device is picking up conversations in a wider radius. So it's picking up the roommates' conversations with their family. It's picking up conversations outside the residence room. And those are really out of scope. And so, next bullet, there's a concern for the surveillance occurring outside the ambit of the consent, which we talked about earlier, and the notice, which I'm going to talk about in a moment. Next bullet. This is particularly a concern for a criminal code violation. Capturing an image of two people interacting would not generally trigger the criminal code provision on intercepting private communications. The moment you're capturing audio, you are clearly intercepting communications, and so then we'll turn as to whether or not those were private communications and so forth. So audio is particularly a concern when it comes to the criminal code. Next bullet. In my view, audio recording should not be permitted as a blanket rule, although one could envision certain circumstances where exceptions might be granted. But in terms of granting those exceptions, you would have to consider that wider radius. What audio is the camera able to pick up, and is it exceeding the notice and the consents that are applicable? Next slide, please. In order for this policy to work, residents and their family members need to come forward with the existence of the cameras so that the previous slides, the measures in the previous slides can be carried out. And the home should then register or log the existence of the camera and also require the resident and their family members to agree to certain restrictions. And these are straightforward restrictions. These should not introduce any concern on behalf of the family or the resident, but they help form the basis to protect both the home's exposure and mitigate the home's exposure, any liability, but also the person placing the camera. I mean, these are things that person should be attuned to in terms of limiting the field of view, no audio surveillance, depending on the circumstances, allowing the home to assess or audit that field of view, remove the camera if the consents are withdrawn, or modify the field of view if the consents are withdrawn. To protect the recorded data, it is capturing images of individuals going about their day, and does merit some safeguarding from a general privacy standpoint. And finally, that the home can, acknowledgement really from this person that the home can remove the camera or ask the camera be removed if it's operated in a manner that gives rise to privacy concerns. Next slide, please. And I think this one is pretty much a given, but in order to manage the reasonable expectation of the privacy of visitors and employees, they need to be notified that the camera is occurring or the recording is occurring. And so a notice sign placed on the door of any room with a camera should be deployed, and it would basically say that surveillance is occurring and to whom questions can be directed to. This is fundamental to ensuring that folks beyond that resident are aware of the recording and can then manage their expectations of privacy as a result. And then the final piece, next slide, is proactive communication. How will you as a home communicate the existence of this granny cam policy to residents and their family members? And I, in a sense, I leave it to you to think that through, but it's important to ensure that there is awareness that there is a protocol for using a camera, that the individual who's placing the camera does face legal risks and liability, particularly if they use a camera that doesn't follow these basic parameters in the granny cam policy, and that family members and residents really need to come forward with these cameras rather than covertly install and use them. So this wraps up my formal presentation, but I'm happy to take any questions.
Daniel, you do have one question, and it relates to geolocation technology. What are your views on such devices being applied to residents with dementia? Does that present privacy issues?
Certainly, if you have the consent of the substitute decision maker, it does not, right? And the notion being that that's the person who's standing in the shoes of the resident and is able to say, yes, I consent to the fact that the location of my resident will be monitored. If the technology is being deployed over the objection of the substitute decision maker, I think that's a particular issue that we would want to work through. But my hope would be that the substitute decision maker would be on side with the use of that technology. It's a little bit different than the granny cams because it only affects the privacy. Well, I should take a step back. It primarily affects the privacy of the individual who has the technology deployed on them. Now, obviously, as two individuals with the technology deployed come into contact, you're learning that those two people, spent some time together in an area and whatnot. But that's, in the sense, that's the point of the technology, is to know where individuals are. So on the whole, I don't see it as an issue if consent's obtained. But if the substitute decision maker is objecting, then I think it's important to have a conversation and explain the benefits of the technology to them.
And actually, we have another question. I'm going to suggest Daniel take a look at it, and if it's easy to answer, he'll answer it to the same level he would have in this seminar, and we can get that out to you. We're at the end of our time, so I want to start by thanking you all so much for being here today. We really appreciate the opportunity to interact with you on these really important topics. I want to remind you again to please complete the survey. Let us know what you thought of the seminar, and let us know if there are other topics you'd like us to address in the future. We did get some questions before the seminar that had to do with capital issues relating to constructing long-term care homes. The issuance of licenses, those were great topics. They didn't really fit in with this seminar today, but maybe we'll do a separate one just on those sorts of issues. And finally, I want to encourage you to go to the Knowledge Center on the Fasken website for more information about COVID-19 and its effect on healthcare in Ontario and Canada. So thank you again for your time. Have a good day.